just before we start, yesterday afternoon at about 3, the temperature, at least up here, became intolerable. The air conditioning seems to be better today, but if at any point it does become intolerable, we can take a 5 or a 10-minute break. So don't feel that you have to hold back.
Don't faint.
Don't faint.
I'm obliged. So the graveyard shift actually falls to me rather than Mr. Holmes. I'm going to be dealing with ground 1 of Intas's appeal relating to dominance, and also with part of ground 2 of Intas's appeal, which is the argument we heard from Mr. Palmer yesterday concerning the alleged requirement for imposition in relation to unfair pricing. Like Mr. Palmer, I'll spend quite a bit longer on the first set of points than the second. Mr. Holmes will then deal with issues of abuse, unfairness and economic value. Professor Bailey will then deal with the discrete issue of comparators as they relate to unfairness, some of the issues around the end of the abuse, and then penalties. Starting, if I may, with dominance, I'd like to organise my submissions as follows, if I may. First, I want to start by making some introductory remarks about the issue of dominance as it arises on this appeal, and to show you some of the basic undisputed facts about the Intas period specifically. Second, I'll take you to a handful of authorities on dominance. Third, I'll deal with the dispute between Intas and the CMA as to whether the CAT endorsed the CMA's findings on the so-called assured customer base. I'll show you that the CMA's point was indeed endorsed in the judgment, and given the sharp dispute about this, I'm going to spend some time on that point. As Mr. Palmer said today, it's a point that runs right throughout Intas's appeal, at least in relation to the liability issues of dominance, abuse and economic value. And then fourth, I'll show you why, in my submission, the analysis of dominance in the CAT's judgment discloses no error of law, and to the extent necessary, I'll deal briefly with our respondent's notice points at the end. Turning to my first topic, as your lordships know, on this appeal, dominance is only challenged in respect of the Intas period, the small final sliver of the CMA's overall finding that Auden Actavis abused its dominant position across a period of 10 years. To be completely clear at the outset, the CMA found that Accord remained dominant throughout the entirety of the Intas period, and that its pricing during that 18-month period was unfair and abusive, again, throughout the entire period. It was not merely a question of the lingering effects of a previous abuse. Now, in argument yesterday, my Lord Justice Green put the point to Mr. Palmer that the facts are fairly clear in relation to the Intas period, and that the real question may be whether the tribunal properly grappled with that discrete set of facts. And of course, that is indeed how Mr. Palmer puts his case. It is essentially, at its heart, a complaint that the tribunal failed to address Intas's arguments. In other words, it's a form of inadequate reasons challenge. And really, in my submission, Mr. Palmer has to put the case that way, because dominance, to state the obvious, is a question of fact. And indeed, it's a highly fact-sensitive issue. It was analysed extensively by the CMA in its decision, and then considered again by the tribunal in the context of what was essentially a full trial on the merits, including by reference to oral evidence given by the party's expert economists. And any appeal against those factual findings would, of course, need to meet the very high threshold that this court has emphasised in a number of competition appeals, including most recently paragraph 42 of the Phenitoin 2 judgment. Now, in my submission, the facts of this case do provide a clear and compelling picture of dominance in the Intas period as before. So much so that even if this court were to conclude that the tribunal had somehow not adequately grappled with them, it would make no difference. In fact, however, what the tribunal did is to uphold the CMA's findings on dominance, not just in terms of the outcome, but in terms of the thrust of the substantive analysis. The factual findings in the decision essentially do form part of the reasoning of the CAT. As my Lord Justice Zacaroli observed this morning, the CAT in its judgment did not merely uphold the CMA's finding of dominance as to the outcome, but said that there was no material error in the CMA's analysis of that issue. And can I immediately show you one further important paragraph from the judgment that goes to this question of endorsement. It's at Core Bundle Volume 1, tab 16, at page 405. It's paragraph 240, subparagraph 1. This is in the context of the CAT explaining why it considers that it has jurisdiction to remake the decision on market definition, having decided that the CMA's market definition should be set aside. And what the CAT says here is that almost without exception, we have accepted, quote, the primary findings of fact in the hydrocortisone decision, the detailed findings of fact. And as the CAT says here, those embrace, among other things, the relevant products, the regulatory regime, and the history and description of the market. In my submission, that's important, particularly when one considers the question of the assured customer base, because those findings, those factual findings in the decision, appear as part of the CMA's detailed analysis of the regulatory regime. And as the tribunal says here, those are the primary findings of fact that we have, almost without exception, accepted. I'm going to come later to the fact that the CAT also specifically endorsed the findings in the decision concerning the assured customer base. But ultimately, in my submission, what this endorsement of the CMA's findings means in relation to dominance and more generally is that Intas is in substance challenging a factual finding made by the CMA on the basis of its evaluation of the evidence and then upheld by the CAT, and that does need to meet the high threshold.
This is under the heading market definition.
It is.
Is that just product market definition they're talking about here, or is it market power within the product market?
So this is before one gets to the analysis of dominance.
Yes.
But the point I was making is that what the CAT is here saying is that it's accepting the primary findings of fact in the decision, including in relation to, among other things, the regulatory regime. The findings that the CAT makes in relation to the regulatory regime, as we see from the decision, I'll come back to it, include all of the findings in relation to the assured customer base, and the CAT is making clear here that it endorses, among other things, those findings.
Okay.
Now, Mr. Palmer spent a lot of time on the facts yesterday. If I may, though, I would like to take you to what the CMA says are some of the key undisputed facts which underpin the finding of dominance in the decision, and to focus in particular on what we can derive from the decision in relation to the Intas period specifically. And those undisputed facts provide, in my submission, a basic reality check in relation to Mr. Palmer's submissions on dominance, and indeed on abuse, where his case is that the Intas period was characterised by workable competition. And they show that in fact...
I'm just looking at I just want to be quite clear as to what it is that's being endorsed. Section 5, deciding the issue of market definition. Again, looking at the index, that is prior to any analysis of dominance. So, a finding by the CMA that there is a secure customer base, would that fall within that rubric in 2401?
In my submission, yes, because what the CAT is saying, and we'll see that it's actually in the context of market definition that the key specific endorsement in relation to the assured customer base appears, and I'll show you that.
Okay, all right.
And because what is being said here is that the primary findings of fact made by the CMA concerning the regulatory regime, those are the primary findings of fact that have been accepted according to this rubric. That is the part of the decision which contains the findings in relation to the assured customer base. It's the bit of the decision that says...
Well, we want to look at that audit trail. Given what's been said today, we are interested in what has been endorsed, what hasn't been, what's addressed, what...
I'm going to do that in quite a bit of detail when I get to the assured customer base. I was just setting it up with that general endorsement. Now, in relation to what I call the undisputed basic facts, can we start with market shares? And if we could turn up figure 4.13 of the decision, which is at core volume 3, tab 23, page 1035. So here we can see Actavis's market shares measured by monthly sales value for 10 milligram tablets during the post-entry period only, so the period after which we start to see competitive entry by the skinny label suppliers. Yeah. I'm going to focus on 10 milligram because, as the court knows, the CMA made no finding of dominance in relation to 20 milligram tablets during the Intas period. As you can see, the large ocean of dark blue is Actavis's market share, and the other colours are the so-called skinny label suppliers' market shares, and we derive some important points from this figure.
So when referring to market share, that assumes we know what the product market is. But here, we're just looking at 10 mg hydrocortisone, in other words, the chemistry tablets. We're not considering substitutability with other potential alternatives, or is this the conclusion of a section on product market?
This comes after the CMA has adopted its market definition.
Right.
The various respects in which the CAP differed from the CMA on that make no real difference because, for example, Plenidrin is drawn into the product market, but the market shares on that device are so small that they really don't affect the points I'm making.
No, we understand that, yeah.
But indeed, so this is shares of hydrocortisone tablets only, both full label and skinny label. As I say, the large expanse of dark blue is Actavis. The rainbow of other colours is the skinny label suppliers. You can see that Actavis' share is always a long way above 50%, a significant legal threshold for reasons I'm going to come to. That is certainly the case during the Intas period, beginning in January 2017. And the trend in relation to market shares is not one of consistent decline, let alone decline throughout the Intas period. What one sees is an initial loss of market share from a starting point of monopoly, and that's when the skinny label suppliers begin to enter the market towards the end of 2015. That happens prior to the Intas period, but there is then a plateauing, or if anything, a recovery. And in terms of value-based market shares, the position at the end of the Intas period, actually just off the end of this graph, but at around June 2018, Intas period ended in July 2018, was 86% measured by value.
So this is all by value? This is by value.
My lord, you yesterday raised the question of what the right metric for measuring market shares is. It's true that value-based shares, such as you see in this diagram with the CMA's preferred metric in the decision, that's actually explained in some detail at paragraph 4.185 to 4.190 of the decision, which you have at core volume 3, tab 23, page 1015. I'll just show you that very briefly. Page 1015. Could we just scroll down a bit, please? Yes, 4.185, the appropriate metric. And if we could go over the page, yes. So the CMA here cites from some commission decisions in the pharmaceutical markets specifically, and in particular refers to the AstraZeneca decision. And you'll see at 4.187, AstraZeneca in that case was arguing that volume is a better reflection of competition in the pharmaceutical market than sales measured by value. And the Commission says that that contention cannot be accepted where the products are differentiated in nature. Sales in value and their associated market share will, according to the notice on market definition, usually better reflect the relative position and strength of each supplier. And that guidance is said to be also relevant to the pharmaceutical sector.
That's where the products differentiate in terms of dosage forms, pack sizes and strength. That's not the case here, is it?
That's true. But what we know, and what we'll come back to, is that on any view, there was differentiation between the products as to the full label versus the skinny label indication.
Not intrinsically, only in terms of market.
No, that's true. And of course, the CMA has plenty of points to make about whether that amounts to a legitimate form of economic value. But what I was just hoping to show you, my lord, is the basis on which the CMA took the position that the value-based market shares were the preferred metric, if you like, by reference to this decisional practice in the pharmaceutical sector. Mr. Palmer said yesterday that the tribunal had rejected the CMA's reliance on value-based shares. That's not right, and he didn't point you to anything in the judgment that did that. But in any event, that is something of a sideshow because as you saw, the judgment presented both value-based and volume-based market shares, and of course, unsurprisingly, it used the CMA's figures in doing so. And if we could go, please, to page 1035 of the decision, you'll see that the CMA, I'm sorry, over the page.
1036.
Yes, figure 4.14.
This is based on volume.
Indeed.
This is a very slightly different graph, but
Yes.
But
So
in the period we're concerned with, although there's a dip in the sort of second half of 17, it then goes back up again.
yeah, so exactly, my lord. So essentially, you see the same pattern as I showed you in relation to the value-based shares, the same trend. The absolute shares are, of course, lower, reflecting the price premium that was being charged by Actavis in relation to these products, that we're going to come back to. But again, during the Intas period, what we see is that the decline has already happened, and there is then, at the very least, at least on average across the period, of plateauing. There's some variation, but by the end of the period...
It doesn't show a distinct drop-off of...
No, it doesn't, not during the Intas period, and in fact, specifically in this case, at the end of the Intas period, Accord's market shares were at the level of 53%.
Yeah.
And that's compared with 86% when measured by value. So the story told by these diagrams is one of very high absolute shares persisting throughout the Intas period. Now, very importantly, what these diagrams also show is that those high absolute market shares are set against a fragmentary cluster of much smaller competitors with much smaller individual market shares. And you can obviously see that clearly from the diagrams also. And that's a point that's of significance when I'll show you in a moment some of the case law. Could I...
I doubt it's a dispute that the distribution of market shares is important.
Indeed.
Because that's an indication of the power over price. That's the counterpoint. All these structural matters are clear. Market share hovering around possibly a bit below on times 50%, even taking the most optimistic basis for Intas.
Yep.
Much higher otherwise. But the question is, what is if the test is the ability to act independently on the market? The question is, what happens to the presumption of dominance at around 50%, or the inference of dominance? Is it rebutted if you see a lack of ability to regulate, to control price?
Yes, I'm going to come on imminently to the pricing evidence, and we say, of course, I can't get away from the fact that one does see a price decline, but I'm going to make submissions about why that is not incompatible with a finding of dominance and doesn't rebut the presumption arising from market shares at this level. Before I do that, there was some discussion yesterday of the comparison between the facts of this case in the Intas period and the facts that were being considered by the CAT and this court in the Sinvan appeal, the liothyronine case. My lord, as you know, CMA's infringement finding in relation to liothyronine, unlike in this case, ended at the point at which competitive entry began. So in that case, one had market shares of 100% for the relevant drug right throughout the infringement period. That was essentially as a matter of administrative priority. The CMA made clear it was not making a positive finding that there was no dominance in the period following competitive entry in that case. But it is significant in my submission that what happened after entry in that case, and you can see this from the CAT's judgment in Lio, paragraph 246, which I'll just turn up briefly. It's Authorities, tab 53, page 1517.
Sorry, paragraph.
Paragraph 246. And you can see there that the appellants were submitting that the post-entry market developments bore all the hallmarks of workable competition, significant market share fluctuations. And what you see in that case is that within 1 year of entry, Advance's market share had dropped by 85%. I only really show you this because there was some discussion of the comparison between the facts of this case, but in my submission it is striking that what one sees in this case is that despite entry, over a period of a number of years by a number of suppliers, we see the pattern that I've just shown you in relation to market shares. It's by no means tumbling down in the volumes one saw in the Sinvan case. So that's Sinvan. Turning next, my lord, to prices. As I say,
Can I just say one comparison? I mean, we were shown, I think yesterday, paragraph 291 of this judgment, and it was said these are the CAT's view of defining features of dominance. They plainly don't analyse the Intas period. In Sinvan, there was a detailed analysis of the glide path as there was new entry, and the economists were cross-examined upon it. and the view of the CAT was that it remained uncompetitive. It was sticky or gelatinous, were the words used.
Yes.
But we don't see that analysis in this judgment.
In the judgment.
In this judgment, in this case.
Yes. Yes. So I'm going to take you first to the CMA findings on prices.
Yes.
I'm going to address you on that particular point, and then, as I say, I'll come later to the judgment. Except the findings in the judgment are quite concise. It's partly why I was pains to show you the endorsement of the actual findings.
We understand the endorsement point. It's important.
No, of course.
But we have to see where it takes us.
Of course. So if I could remain with the decision for now, as I say, there's obviously no dispute that prices were falling in the Intas period. That was one way or another due to the effects of competitive entry, and there's a debate in this case about whether that was due to the direct constraint from the competitive entrants, whether it was indirectly via the drug tariff mechanism. But either way, prices were coming down, and the reason they were coming down was competitive entry, and the CMA doesn't shy away from that and recognises that in the decision. Now, no doubt falling prices in many cases may indicate workable competition, lack of dominance. To state the obvious, that all depends on the facts. In this case, however, the CMA took the view that a proper understanding of the facts showed that Actavis enjoyed a position of market power despite the overall trend of falling prices. It was self-evidently not able to resist reducing its prices, but that does not mean that it was powerless, as Mr. Palmer put it in submissions yesterday. And now, during discussions yesterday, there was, again thinking about the Sinven case, there was a suggestion that this case may differ from the Sinven case because competitive entry in the present case has resulted in prices getting, I think someone used the phrase, to ground level. It's true that that did indeed happen eventually, but can I just make sure that the court clearly has in mind where the Intas period sits on the downward slope of the Matterhorn? I'll take that from figure 1.4 of the decision, core bundle 4, tab 24, page 1750. We've actually produced some large hard copies, which it's purely of the diagram from the decision, which may or may not be helpful.
Yeah.
Could you hand on? It's on the screen in any event.
What page of the decision is this?
Well, you've raised a good point. It's actually not the figure as it appears in the decision, because the figure that appears in the decision has a small labelling error, because the line reflecting the...
I mean the one on screen, not the one you're handing up.
Yes, so the one I've handed up is the one on the screen.
Oh, I see. Where can I find this in the bundle then?
Page 1750 of the core bundle, which is, as you'll see, not actually an extract from the decision. It's purely because this happened during the trial rather than during the appeal proceedings.
Okay. For our purposes, then, we need to know to the extent to which this is agreed or disagreed, or...
I don't anticipate there's any issue, because this is a figure that was before the CAT, and it simply corrects one small labelling error.
I understand that. I just want to make sure that Ms. Ford is nodding sagely.
I'm very grateful. I really don't see that there can be any issue. I hope not, anyway. So, as I say, so this is one of the various depictions of the so-called Matterhorn. You can see from the key at the top, there is a label, a second label from the right, Jan 2017, end of 20 milligram unfair pricing abuse. Now, as well as being the end of the 20 milligram unfair pricing abuse, that is also the start of the Intas period. You can see Actavis's prices for 10 milligram tablets, which is the thick red line, at the start of the Intas period in January 2017, are at around £55 per pack, and have obviously already started coming down from the apex of the mountain at above £70 per pack. And then over the course of the Intas period, which ends in July 2018, so the next label along, that was the correction, because that label was in the wrong place in the decision, which was slightly confusing. That's the only difference between this and the version that appears in the decision. You will see Actavis's prices have dropped to around £20 per pack at the end of the Intas period. It's very important to note, however, that that is still very far above the cost plus level as calculated by the CMA, and that's the purple line almost horizontal at the bottom of the graph. £20 is not the point at which prices reached cost plus or any competitive benchmark. It is the point at which, as a matter of administrative priority, the CMA decided not to continue with its investigation of unfair pricing. And just
I think the same point was taken. There was 2043, I seem to remember, in Simon, which was a price which was in the market. But there has been an issue which has sort of trickled along sub silentium in all these cases, that no one says you have to price at cost plus. You know, cost plus could be £2, but if you were pricing at 4 or 5 or 6 or even 10, there's no necessary correlation between that and an abuse. No one's actually taken that case yet. These are very, very clear cases. So to say that it doesn't hit exactly cost plus doesn't necessarily indicate that that's the point at which abuse would start.
No, and I'm not making that submission, to be clear. I'm actually still talking about dominance and was responding principally to the discussion yesterday that I had understood to suggest there may have been an understanding in the court's mind that the bottom of the mountain had been reached by the end of the Intas period. Perhaps I was wrong. No. But I just wanted to make sure you had it.
I don't think we really addressed that, but we knew the prices were coming down. We saw the graph.
Of course.
We didn't know where it went on from there.
But I am focusing here on dominance, so not the question of whether one characterises these prices as abusive, but it is relevant to dominance, and Mr. Holmes will come back to these points in relation to abuse, of course. But the £20 per pack level that one sees at the end of the Intas period, as you see, that is significantly above the cost plus level. There's some figures in the decision, in fact, which say that £20 per pack exceeded cost plus by 821% during the Intas period specifically. Just for your note, that is table 5.30 of the decision, core volume 4, page 483. In any event, you can see the picture from the diagram. If I could just also turn up, please, table 1.3 in the decision, which is at core volume 3, tab 23, page 668. If you just do, so table 1.3, prices of hydrocortisone tablets over time. You can see here that the price charged at the end of the Intas period, in other words, the £20 per pack at which the CMA essentially stopped investigating, it was vastly in excess of a number of these other metrics still at the end of the Intas period. So it was very far in excess of the price charged by Auden when it first launched generic hydrocortisone tablets in April 2008. There's a comparison with the average price of skinny label tablets once one got to a period in February to April 2021. And in fact, there's a specific figure for that comparison on page 1179 of the decision, which again I don't need to turn up, but the difference there in percentage terms between the £20 price at the end of the Intas period and the average price of skinny label tablets in that later period is in the region of 2,500%. And then also, there's a very significant excess between the price that was being charged at the end of the Intas period and the prices that Actavis was charging once one got to that same period in February to April 2021.
Okay. Take all of these facts as an absolute given.
Yeah.
Coming back to this, does this demonstrate that Intas during this period had power over price?
Well, I'm going to come now.
That may be the real nub of this issue, given everything you said, which is a contrary indication. Does it nonetheless demonstrate power over price or the ability to act independently on the market?
So in my submission, it's extremely relevant to that analysis that, by reference to all of these other metrics, including essentially the price that the market solidified on a number of years later, during the Intas period, we're still well above those levels. But the point I'm about to come on to now is the relative price differential, and indeed the absolute price differential that Actavis was able to maintain as compared to the skinny label suppliers, again during the Intas period, because that really is direct evidence of the sort of pricing power one requires in order to support a finding of dominance. My Lord, you made the point in the course of argument on the imposition point yesterday that dominance doesn't require absolute pricing power, we respectfully agree. It requires a degree of pricing power, the ability to maintain prices to some extent above the competitive level and profitably so. So may I show you the evidence on that? And this is a key part of the CMA's analysis of dominance, and as I'll show you, it's also endorsed in the CAT's judgment. We can pick this up, please, at page 1044 of the decision, figure 4.17. So that is a clear depiction.
Page, sorry, 1000.
1044, my lord. So this is prices and drug tariff prices of 10 milligram hydrocortisone tablets during the post-entry period specifically. And the red line is, thick red line is Actavis's prices, and then the dotted grey line is the prices charged by the average prices charged by the skinny label suppliers. And as you'll see, it shows the very substantial price premium that Actavis was able to maintain above the average prices charged by the skinny label competitors as they began to enter the market. And we see that differential persists throughout the Intas period, which, as you know, starts in January 2017 and runs until the end of the graph. And then, if we could move over a few pages to figure 4.19. This is another depiction of the price differential. It shows the difference between Actavis's prices and the skinny label supplier prices for 10 milligram tablets in both absolute, and that's the left-hand y-axis, and relative terms, which is the right-hand y-axis. And what you can see is that at the end of the Intas period, the absolute price difference between Intas's prices and the average prices of the skinny label suppliers is still above £15 per pack. In fact, to be precise, it's £16.60 per pack. And the relative price difference is in the region of 500% higher than the prices of the functionally equivalent tablets sold by the skinny label suppliers. So a differential of over £16.60 per pack, over 5 times higher than competitors' prices, and that's still the position by the end of the Intas period. So that is after an 18-month period involving further entry by multiple new suppliers who, according to my learned friend Mr. Palmer, are supposed to have provided a fully effective constraint on Actavis's pricing and to have introduced workable competition during the Intas period. Can I just show you what the decision said about these price differentials? Paragraph 4.274. Yeah, sorry, it's over a couple of pages, thank you. So CMA says it's important to consider these price trends in the context of the changes in market shares as set out above. Actavis's market share declined initially at a time when the absolute and relative premium between its price and that of its competitors was growing. That was prior to the Intas period. However, Actavis's market shares then stabilised at a time when its competitors' prices continued falling faster than its own prices. This is direct evidence that Actavis was not losing any market share despite its competitors' tablets becoming relatively cheaper in relation to its own, provides a strong demonstration that Actavis retained an ability to price above competitive levels, thereby demonstrating its market power. And there's actually another important point, as well as the point about the price premium within this paragraph. Mr. Palmer gave you a downhill skiing analogy, but what we see from this paragraph is that during the post-entry period as a whole, the skinny label suppliers were going faster than Actavis was in the race towards the bottom of the mountain. And that's the point that the CMA makes in terms also at paragraph 4.272a. Now, Mr. Palmer suggested on a number of occasions yesterday that Actavis's position was somehow precarious during the Intas period, and that it could not have known whether the large pharmacies like Boots or Lloyd's might switch away from it at any time. His whole argument on competitive constraint, both in the tribunal below and on this appeal, is that Actavis was competitively constrained by the fact that it didn't want to trigger the large pharmacies to revisit their attitude to the regulatory issues. And I'm going to come on to the evidence on that. My submission based on this material from the decision is, if that really was an active and effective constraint, why would Actavis have allowed such large price differentials in both absolute and relative terms to have persisted right the way throughout the Intas period? In my submission, the CMA was right to regard this pricing evidence as clear and compelling evidence of Actavis being able to behave to an appreciable extent independently of its competitors when it came to setting its prices. The characteristic hallmark of dominance. Yes, prices were falling, but they were still well above the prices of its key competitors. So, very importantly, my lords, none of this factual material from the decision is contested. And in my submission, in light of these facts, 86% market shares by value, 53% by volume, right through to the end of the Intas period, and prices still well in excess of both the skinny label suppliers' average prices and also the various other metrics I showed you, including the cost plus metric. It was entirely unsurprising that the CMA should make a finding of dominance in relation to the whole of the post-entry period, including the Intas period. Now, one final point before I turn to a few of the cases on dominance. You'll have seen, of course, that the CAT, to some extent, criticised the CMA for not taking a sufficiently phased approach to the question of dominance. I hope, as you'll have now seen, the decision is actually replete with specific evidence relating to the Intas period. That's in all the figures that I showed you. So in my submission, there was a clear factual bedrock when it comes to looking at the fact of the CAT judgment itself for findings relating to the Intas period specifically. You see that in the decision.
Well, significantly, it doesn't. The CMA didn't simply average out.
No, exactly.
The figures. I mean, if it had averaged out the figures, then that would be a good point, because you wouldn't be able to distinguish between the different periods.
Yes. Yes.
But I mean, from the material you've shown us, we've got figures both before and after the Intas period, and from some of the figures right the way through.
Yes.
From the outset.
So the CMA adopted a broader distinction between pre-entry and post-entry, and that was the framework for its analysis of dominance. That's true. And the CAT thought a more granular approach that looked at the different periods of ownership was the way to go. And I'll come back to that. But in my submission, there's no difference in substance, and the CMA really was focusing on the relevant facts during the period to which Mr. Palmer's arguments relate.
Just so I can be clear, because I'm a little bit lost as to where we've been looking at these graphs, where they come from, but we saw in the CAT's judgment over a number of paragraphs setting out tables of market share, volume and value over each of the separate periods.
Yeah.
Is it right that all that information was in the decision? It just wasn't separated out in that way?
I'll be corrected if I'm wrong, but the data underlying... Yes, well, I won't be corrected because I think I'm...
You might be somebody else.
The data underlying the tables to which my lord refers in the CAT judgment is the very same data that underlie the colourful market share graphs that I showed you earlier. It's just a different way of presenting the same data points. Yes, exactly. Could I turn then...
That's what they say. I think it's paragraph 240, subparagraph 2, where the CAT says that they've been provided in manipulable form the data which is in the decision, and they've used that data.
Exactly. I'm grateful. Thank you. So, with those, as I say, essentially undisputed facts in mind, if I could turn more briefly to the law. The well-known phrase about sucking eggs springs to mind here, but I do think it's helpful to spend a little bit of time on this, given the nature of some of the arguments from learned friend for Intas. If I may, I'll start with the basic test for dominance. It is the same test regardless of whether one is dealing with an exclusionary abuse or an excessive pricing abuse. I understand there to be any dispute about that. That can be seen, among other places, from the United Brands case, which you have in the first authorities volume, tab 1. And it's paragraph 63 of the judgment. I'm sorry, I don't have a page reference. I'm just going to find it.
You need to keep going down.
I'm so sorry, yeah, it's quite... Thanks a lot, fine.
You'll need to go quite a long way down.
Yeah.
This is the head note still.
Yeah, I'm so sorry.
66, I think.
It's still further. It's still
Yeah, I'm sorry, it's page 65 of the bundle. Paragraph 63, so it's towards the... Sorry, up a little bit. I'm sorry to take so long to get to the very, very famous words that probably many people in this room know by heart. Second line from the bottom of the page, this is the classic formulation of dominance, a position of economic strength enjoyed by an undertaking which enables it to prevent effective competition being maintained on the relevant market by giving it the power to behave to an appreciable extent independently of its competitors, customers, and ultimately of its consumers. And I lay emphasis on the words appreciable extent in particular. They show, and this is not a controversial point, that dominance does not require a complete absence of competition in relation to price or any other parameter of competition. It's of course not only monopolists that can be dominant. That's a point that's made in terms in United Brands. We don't need to go there with paragraph 116 of the judgment. An undertaking does not have to have eliminated all opportunity for competition in order to be dominant. As it happened on the facts of that case, United Brands' share of the relevant market, as found, was below 50%. Now, the reason why I emphasise that point is probably obvious, but it's because of the way in which Intas puts its case. Because, for example, at paragraph 12 of its primary written submissions, its appeal skeleton, what it says is that the entry of the skinny label suppliers introduced a restraint on Accord's prices, which, and this is a quotation, stopped it from being able to act independently. And in my submission, it's clear from the law, complete independence is not the test. The test is appreciable independence. Put another way, dominance is a relative concept. It involves an assessment of the degree of the allegedly dominant firm's independence from its rivals, and looking at whether the allegedly dominant firm is subject to appreciably less competitive pressure than its rivals are. In my submission, that's why the pricing differential evidence from the decision is so important in this case. And I'll show you how that basic proposition about dominance as a relative concept is made in terms very clearly by the General Court in a case called AstraZeneca, which I'll show you in a moment. So that's the basic test. I've already made the point that dominance is an intensely fact-sensitive issue. It involves looking at a range of factors, and that's the approach of the CMA in the decision, and indeed the CAT in its judgment, as I'll show you. Neither the CMA nor the CAT solely looked at market shares. However, the law does afford special significance, in my submission, to market shares as an indication of dominance. And in my submission, Mr. Palmer's arguments on this point significantly underplayed the importance to be attached to market shares, no doubt driven in part by the inescapable reality captured in the diagrams I've showed you from the decision. The basic point in my submission is that market shares are not just one factor among many that go into the melting pot when one is looking at dominance. They have a special legal significance. There are very many cases that make that point. It's almost a hornbook principle of EU and UK competition law. They include, for example, the famous Hoffman-La Roche case, on which Intas relies in support of its submission that falling prices are generally incompatible with a dominant position. The point is put in various different ways. Sometimes the language of a presumption is used. Sometimes the authorities speak of very high market shares being proof of dominance. But the essential insight underpinning the case law on this point is that as a matter of economic reality, market power and the absence of workably effective competition tends to be the explanation for very high market shares, particularly where, as Honourable Justice Green noted yesterday, they are stable or sustained over a long period. It's always, of course, a question of fact. Can I please then just show you the EU authority that I mentioned in relation to this point? It's the AstraZeneca case in the General Court in 2010. You have that at Authorities Volume 3, relevant extracts, I should say, at Authorities Volume 3, tab 22, page 663. Very briefly, by way of background, this case involved abusive conduct by AstraZeneca in relation to a drug called Losec for the treatment of various nasty-sounding gastrointestinal diseases. It was not an unfair pricing case. The abuses involved conduct such as misleading various European patent offices to obtain extended protection for its relevant patents. But the common theme of the abuses was that they were designed to prevent the emergence of a rival, therapeutically equivalent generic version of the same drug from coming to the market. So some resemblance to the facts of the present case, but I rely on it for its analysis of dominance. Picking that up on the page here at page 663, at paragraph 224, this is from the arguments of the party. Sorry, if you could scroll down a little bit. You can see that an organisation called the EFPIA, the European Federation of Pharmaceutical Industries and Associations, which was intervening in support of AstraZeneca in the appeal on this issue, argued that in the absence of a thorough analysis of competitive conditions on the market in question, high market shares are not sufficient to conclude that there is dominance, and it was said that this was particularly the case in the pharmaceutical sector. And then at paragraph 225, just down the page, similarly, the applicants submit that the Commission relied excessively on factors relating to prices and market shares. We could move over the page to paragraph 235, over a few pages. Yes, sorry, just one down, thank you. There is a specific argument in the case about a finding that the Commission had made in relation to dominance in Germany. This was a case in which there were distinct geographic markets in different member states. It was said that the finding in relation to dominance in Germany between 1995 and 1997 is erroneous. The factors on which the Commission relies, namely market shares, prices and promotional activity, do not support the finding that there was dominance. The applicants pointed out that during the period between 1995 and 1997, market shares of competitors were significant, and that market shares had declined from about 82% to about 64%, and then down further in relation to another drug. And then at 236, reliance was placed by the applicants on the fact that during the period in question in Germany, prices of various capsules were the same, which indicated that AZ was not able to maintain higher prices than its competitors. And then if I could just show you how the court approached these issues, you could move on to paragraph 242 of the judgment, please. And this is where the General Court formulates the, what I say is the significant points in relation to the importance of market shares. So, as regards, first of all, the relevance attached to the possession of substantial market shares for the purposes of determining dominance, it should be borne in mind that although the importance of market shares may vary from one market to another, the possession over time of a very large market share is in itself, save in exceptional circumstances, evidence of the existence of a dominant position. And then a distinguished set of Court of Justice and General Court authorities are cited in support of that proposition. Pausing there, I'd just note that the Court of Justice in the same case on appeal from the General Court's judgment in AstraZeneca endorsed this, but used a very slightly different formulation. It talked about very high market shares being proof rather than evidence of the existence of a dominant position. Just for your note, paragraph 176 of the Court of Justice's judgment, which is at page 816 of the Authorities Bundle, Volume 3. If anything, that's a stronger formulation of the basic proposition. Then paragraph 243 on the same page, the General Court explains what it means in paragraph 242 when it talks about very high market shares. As I say, this is familiar stuff. Market shares of more than 50% constitute very large market shares, and a market share of between 70 and 80% is in itself a clear indication of the existence of a dominant position. Paragraph 244, the General Court observes that the Commission did not, unsurprisingly, it did not base its examination exclusively on AZ's market share. It looked at various other factors. But then at 245, on the top of the next page, the Court nonetheless points out that the Commission could not disregard the importance that had to be attached to AZ's generally very large market share throughout the entire relevant period in all the countries concerned, and it's described as always the leading player on the relevant markets. Now, can I just, I'm sorry, just in terms of just completing the picture, so what the General Court then does is it goes through the position, in particular in relation to market shares in each of the various member states that were an issue in the case, finding that the high absolute and relative market shares in each market were, quote, an entirely relevant indicator of market power. That's paragraph 253 of the same judgment. And then if we could just go on to page 673, paragraph 255 under the heading price levels. So again, records the point being made by the applicants, the intervener. They were disputing the Commission's finding that the higher prices charged by AstraZeneca for the relevant product amounted to evidence of the existence of AstraZeneca's market power, and the General Court rejects that submission. So some of the Court's reasoning, unsurprisingly, relates to the facts of the case before it. But could I just show you paragraph 266 of the judgment, please? And just at the top of page 678, second line, the Court would point out, as we found above, that the ability of AZ to maintain higher prices than those of its competitors, while maintaining a much higher market share, shows that it was able to exercise market power in respect of price, since neither competing producers nor social security systems, nor indeed patients, were able to force AZ to bring its prices into line with those of competing products. And in my submission, that's a very clear statement in the pharmaceutical context that the ability to maintain higher prices than your competitors while retaining a much higher market share demonstrates market power in respect of price. And you probably have my point that this was very much the position during the Intas period by reference to the materials I've shown you. And one final point before moving on from this judgment. We could pick it up at paragraph 287. Previous page. This is just to pick up the specific point in the appeal concerning the position in Germany. Paragraph 288, the Court notes that AZ's market share in Germany declined during the period selected from 96% in 1993, and it had come down to 53% in 1997. By a spectacular coincidence, the exact final market share that Accord had in this case at the end of the Intas period when measured by volume. And the Court refers to that as evidence of an uninterrupted downward trend, but it says it is still very significant in 1997. And here you see in the final sentence of paragraph 288, a dominant position may be presumed from market shares above 50%. What this shows in my submission is that the presumption arising from market shares above 50% is still operative, even when one has declining market shares. You already have my submission, though, that in the Intas period, rather than being a position of declining market shares, in fact, you had stable market shares well above the level at which the presumption arises. I'll turn then to my third topic, which is the assured customer base. My lords, as you know, this was a finding in the CMA decision about the reason why Actavis was able to maintain such high market shares and to continue to charge at the price premium that it did during the post-entry period. The basic point is that certain large pharmacies, high street names like Boots and Lloyd's, were not prepared to dispense skinny label products for treatment of adrenal insufficiency in adults, so-called off-label dispensing. And so they were not prepared to switch to the skinny label suppliers despite their very considerably lower prices. Intas says repeatedly that this finding in the decision was not upheld in the CAT's judgment. It even Intas, even as I understood them, went as far as saying that the CAT had rejected the CMA's findings on the assured customer base. As I'll show you by reference to the judgment shortly, that submission is just wrong. Mr. Palmer's tour through the judgment's treatment of the issue was incomplete. As was clear from my learned friend's submissions yesterday, and indeed this morning, this is an argument which has substantial importance in the context of Intas's appeal. If I can paraphrase a little, Intas treats the assured customer base finding as if it were one leg of a stool, with the stool being the CMA's conclusion on dominance, such that if the leg falls away, so too does the stool. As I'll show you, however, I hope, The assured customer base finding is not like the leg of the stool. Its role in the decision is to explain why, as I've said, Accord was able to maintain high market shares and continue to charge such lucrative prices well above its competitors. But what really matters in relation to dominance is not why Accord was able to do this, but the fact that it could. Dominance, of course, being the ability to act to an appreciable extent independently of one's competitors. Still less does it matter for dominance whether the views of pharmacies like Boots and Lloyds about matters like regulatory risk were right or wrong. The key point for dominance is that they held those views, and those views drove them to forego substantial sums that would have been realised if they switched to the much cheaper product. Now, obviously the CMA as a responsible regulator wanted to understand the factors which contributed to Actavis's market power, continued high market shares and high prices even after competitive entry had occurred. And that's the context in which one sees the findings on the evidence that have been received from the various pharmacies, and I'm going to show you that in a moment. In any event, as I'll also show you, the tribunal judgment clearly did endorse the CMA's findings on the assured customer base. Now, in terms of what the CMA said on this point in the decision, Mr. Palmer did show you a lot of this yesterday, and I'll try to take this relatively swiftly so that I can get on to the point that I infer the court is interested in relation to how this was addressed in the judgment. But I would like to just go back to the decision in order to emphasise a few points, if I may. So, just to remind you of the key finding, if one goes to Core Volume 3, tab 23, page 721, and it's paragraph 3.113 of the decision. Under the heading Orphan Designation,
I think hot air rises.
I agree, actually, yes.
Yeah.
And we're hotter than you are, so we're
No,
going to
I'm
rise for
extremely
5 minutes and we may come back without clothes.
All right, disabled.
Yeah, I mean, very achieving to finish today. I will show.
Yeah, I was just wondering the same.
Save you time tomorrow. So you'll have the enlivening effect of the voice at the end of my start, but on the other hand, it's much easier to start fresh tomorrow morning.
There's some chocolate here.
Yeah, all the 65 in that.
And is that not enough for the whole period? For the whole infringement?
Yes.
You need to
Yeah. It's got speed. If you want to really go for the maximise. Yeah, there you go. Play your way. What do you have? What do you need? I was going to say, I don't want to disrupt my well-coiffed crop. I've been mentioned for a few years.
What are you interested in? I don't think we're interested in the academics.
Oh.
Okay, yeah, I'm just.
Okay. Yeah, it's also for excellence. Actually, we'll just get very, very red and we'll get quite painful. And then I have to cover it. Live in the nose, otherwise we're in a mess. So there we are.
How are you, Laura?
Yeah, I'm okay, thanks. How are you?
Melting? I'd say. Do you have evidence?
They're not easy.
Yeah,
Am I nicking your water if I pour it in this?
No, I've got my water here. I'm keeping supplied more water.
Just the other bit myself.
Found some toothpaste. Yes, exactly. It looks like it should have toothpaste.
Very much. Do you know Soprano, that area?
the other side.
Already got something. All over the bits and plans. Yeah. No, it's not working. I'm working in my
Which is usually service it goes
around the table.
Thank you for the well-timed adjournment.
And the aircon seems to have come back on.
There we go. So we're on page 721, paragraph 3.113 of the decision. subject to the assured customer base. So you see the heading, the orphan designation. Paragraph 3.113 refers to an Actavis document from January 2015. I think Ms Ford showed you this yesterday. It contains the colourful phrase about the near-term cash cow and the expectation that competitors are going to enter the market soon and erode margins. Then you see the CMA makes the finding at 3.114 that in fact competitors began to enter the market from July 2015 onwards, but prices remained high, inflated by Auden's price increase from the previous 7 years. Having taken over sales of hydrocortisone tablets from Auden, Actavis was also able to maintain a premium over its competitors' prices, and I've shown you the evidence as for the premium. And then this is the CMA's explanation as to why that premium could be maintained at paragraph 3.115. I know you've seen this. It resulted in the CMA's finding from the orphan designation granted to Plenadrin, which from November 2011 meant that no new licences for hydrocortisone tablets could specify that they were for the treatment of adrenal insufficiency in adults. This unforeseen and unintended consequence of the regulatory regime, which had no basis in innovation by Auden, created a barrier to expansion once competitors began to enter the market, and gave Actavis an assured base of customers who reached the view that they could not switch away from its hydrocortisone tablets. As we know, in relation to 10 milligram tablets, Actavis was the sole supplier of the full label product. Just underline the words barrier to expansion in that paragraph. Mr. Palmer yesterday made the point that the CMA had rejected a submission from one of the investigated parties that the orphan designation constituted a barrier to entry, and it's true that the CMA did that, and of course we see that skinny label suppliers did enter the market, but what the CMA, the role that the CMA ascribed to the orphan designation was as a barrier to expansion. It meant that the skinny label suppliers were not able to contest the market in relation to the larger pharmacies. Now, as Mr. Palmer said yesterday, the CMA found there was no formal legal barrier to a pharmacist dispensing off-label. That is, it was not against the law to dispense a skinny label product for the treatment of adrenal insufficiency in adults. That was the distinction between off-label marketing and off-label prescribing. My Lord Justice Green discussed with Mr. Palmer yesterday. So there's no dispute about that point as between the CMA and Intas. The CMA also found in the decision that there was no regulatory guidance that specifically addressed the issue of the off-label dispensing of skinny label hydrocortisone tablets. I think Mr. Palmer took you there, but the key references at paragraphs 3.226, 3.234 of the decision. I'll just show you those briefly. It's page 756, core volume 1. So these are the key findings that I've just summarised, and then just over the page, you can see at subparagraph A, there's a reference to some non-binding guidance from the GMC in 2013 about good practice in prescribing medicines, which recommended that healthcare professionals should usually prescribe medicines in accordance with the terms of their licence, albeit there's a discretion on healthcare professionals to prescribe and dispense medicines for off-label use in particular cases. And then at B, there's also some non-binding guidance from the MHRA, which also recognise that there are clinical situations when the use of unlicensed medicine or use of medicines outside the terms of the licence may be judged by the prescriber to be in the best interest of the patient on the basis of the available evidence. And there's a reference from the same guidance, the penultimate line on the page, prescribers should pay particular attention to the risks associated with using unlicensed medicines. We know also from the decision that doctors usually wrote open prescriptions for hydrocortisone tablets. So in fact, this was really a question of the pharmacist's attitudes as the dispensers to the question of regulatory risk. But as I say, there was no specific guidance on that issue at the relevant time. Now, page 761 of the decision, paragraph 4.239.
3.239. 3.2.
Yes, I'm sorry, 3.239. Yes.
It's slightly further up.
Yes, thank you.
Yeah.
This is the point about the reimbursement mechanism for pharmacies. So this, as the CMA explains, a pharmacy is paid the same amount irrespective of the price that it pays for the drug or which drug it dispenses. The hydrocortisone tablets, this meant that a pharmacy was paid the same amount regardless of whether a full or a skinny label product was dispensed. Given that skinny label tablets were generally cheaper than full label tablets, I've shown you the evidence on that, pharmacies had an incentive to dispense a skinny label tablet to fill an open prescription, as that would have allowed them to maximise the profit they made. So, despite that financial incentive, and despite the absence of a formal regulatory barrier, the undisputed evidence is that the larger pharmacies very largely did not switch to the cheaper product. And if I could show you, Mr. Palmer showed you it yesterday, but it's worth turning back up. Table 3.8 of the decision, and that's at page 783.
Yeah.
So this, these are the 10 largest pharmacy chains. The first two columns you see their total hydrocortisone tablet purchases, whether skinny or full label, for both 2016 and 2017. And I should say, so it's the 10 largest pharmacies, and then at the bottom you have the composite figures for the independent pharmacies, and those are pharmacies either effectively sole practitioners or pharmacies with less than 5 outlets, I think.
Yeah.
What you can see from the list is that Boots and Lloyd's are by far the largest of the named big pharmacies. Boots buys 150,000 packs in 2016, Lloyd's buys 139,000. I think if you add those figures up, they would exceed the volumes purchased by all the independents put together, so the bottom row. These, as you can see, I think if you scroll up a little bit, please. Yeah, so these figures are from the period from March 2016 to November 2017. So after competitive entry starts to occur, obviously, and extending well into the Intas period, which started in January 2017. Now, no evidence has been advanced by Intas, and there's been no suggestion that there was any relevant change in these pharmacies' purchasing patterns after November 2017. If there had been, no doubt, Intas would have brought that forward. And actually, I think Mr. Palmer confirmed yesterday in response to a question from the bench that the position did not change. Did not change during the Intas period. That was page 146 of yesterday's transcript. Now, taking Boots, you can see that it overwhelmingly, and this is the final 2 columns in the table, it overwhelmingly buys full label hydrocortisone tablets. Only around 1% of its purchases are skinny label. Lloyd's is a very similar story, and the same is true for Rowlands and Well, who are the 3rd and 4th largest pharmacies in terms of total purchases. And to be completely clear what that means, in relation to 10 milligram hydrocortisone tablets, which we know from the decision covered 96% of all sales of hydrocortisone tablets, full label meant Actavis because it was the sole supplier of full label products due to the regulatory quirk arising from the orphan designation for Plenidrin. Now, the decision did not seek to quantify the financial impact, if you like, of non-switching, or the size of the incentive that I showed you referred to a little earlier. During the trial, however, the tribunal asked the CMA to do some analysis of this, and I'd just like to show you that, because in my submission it shows you just how assured the assured base was. Could you turn up, please, Core Supplementary, tab 24, page 497. You'll see from the heading, this is a note entitled CMA Estimation of the Additional Cost to Pharmacies in Purchasing Full rather than Skinny Label 10 milligram tablets. I don't think the court has seen this yet, but you'll see from the introductory text that it relates to a request that was made on day 8 of the appeal hearing by the then president. He was asking for an on-paper articulation of exactly how much money the pharmacies are leaving on the table in choosing skinny over full label. I think as the footnote notes, the then president meant to say choosing full label over skinny. And that was the CMA's understanding and the basis on which it produced this note. The text then explains that the estimate was calculated using data already on the CMA's file, and certain limitations of the data are explained in the usual responsible way. But then over the page, we see that the table sets out the CMA's estimates of the amounts that the larger pharmacies would have saved had they switched from skinny label to full label for their hydrocortisone tablet requirements. So in relation to Boots, for example, total saving of 7.5 million across 2016-2017, representing almost half of its total expenditure on hydrocortisone tablets. For Lloyd's, a similar amount in figure, and so on and so forth. And in a sense, this is another depiction of the scale of the price premium that Actavis was able to sustain.
So the total saving is the total figure in the first box.
Indeed.
7721. That's the amounts
indeed.
that would have been saved had they switched.
The amount that would exactly.
And that, you say, gives an indication of the stickiness of the full label price.
It does.
So it's an indication that they were, for whatever reason, unprepared to switch.
Yes.
These are the most sophisticated of all the customers. I mean, it's unlikely they would have been persuaded by irrational regulatory fears.
Yes. Well,
ill-founded regulatory concerns. I mean,
yes.
They par excellence know about the difference between the right to prescribe them and dispense something which isn't branded.
Yes.
Yes. I mean, that gives you a good indication of the degree of stickiness, if you like.
Yeah, so and that comes back to my point about dominance, the key thing being the fact of the ability to charge the premium, to rely on the lack of switching by your customers rather than the precise explanation.
Yeah.
And as I said, the quantitative evidence is not in dispute, and this material, this table was based on evidence that was already in there and on the file. Don't recall there being any disputes over the figures at the trial. It's cited in the CMA skeleton for this appeal, and Mr. Palmer hasn't addressed it. In my sense, in relation to dominance and the assured customer base, one could really stop there, because the quantitative evidence shows that these large pharmacies formed a large, reliable block of demand that wasn't price sensitive, wasn't sensitive to the lower prices offered by the skinny suppliers.
Sorry, it's suggested, I think, on Intas's behalf, that there are other reasons why the big pharmacies would be interested in Actavis's product, logistics, being able to supply volume. And the volumes are very different. Was there any evidence about the ability of the skinnies to provide that sort of volume to the big pharmacies with sufficient consistency and certainty? But all those other reasons, let's not debate whether they're right or wrong. Are they relevant to dominance at all? Or they only come into play at the question of abuse?
Yeah, so my submission, I can't see that they're relevant to dominance. And that's another version of the point I was just making. Really, dominance being the ability to charge a price premium over your competitors, to act appreciably independently of competitive pressures.
In relation to one of the graphs, that Actavis had 50% or more pretty much at every stage, both in terms of price and in terms of volume. No doubt, because they could make a lot. The skinny producers were all relatively small operators in the market. Was there any evidence as to their capacity for actually producing more tablets?
Frankly, going to have to come back to you on that. I don't know off the top of my head. In relation to that,
it must be one of the things that I mean, an outfit like Boots or Lloyd's or Superdrug would have well in mind.
Yeah,
it's all very well. We're paying, as it were, a premium price for these full label tablets.
Yeah.
So should we change to skinny label tablets? But then, their marketing and sales staff, managers are going to be saying to them, well, that's all very well, but if we switch to these small manufacturers, we could find ourselves running out of product, empty shelves. We're not going to be able to supply our customers. So we're not going to do that.
Indeed. So
their total demand on this may well have been higher than the capacity of various individual skinny suppliers to supply.
Yeah.
So
they wouldn't necessarily want to go from a full label supplier, one supplier, to 5 skinny label suppliers. You've then got 5 potential loads of trouble.
So I'm going to show you in a moment what the pharmacy said to the CMA about their reasons.
Yeah, sure.
In relation to the various other factors, my Lord Justice, those factors, they're relied on in relation to the question of economic value, potential other reasons why the price premium that we see differential above cost plus was evident. Mr. Holmes is going to address that when he comes to the Intas arguments on abuse and economic value. I think, in terms of the specific question of whether there's any evidence of ability to meet demand, I'll check with the CMA and we'll come back to you if we may.
Well, we're not triers of fact, we're just curious.
No, of course. No,
dangerous.
I'd like to be able to give you that.
But I mean, if it's in the decision, it's in the decision. If it ain't, it ain't.
No, exactly. That will be the limit of my inquiry.
Then it's a question of what's in the CAT judgment.
That will be the limit of my inquiry.
If it's not, it's just, you know.
I mean, I would just say that the skinny label suppliers were not necessarily I mean, there were pharma companies like Teva and so on. I mean, they were.
Well, then you're into ancillary questions whether they can increase capacity to meet that security of supply that a very large buyer like Boots would demand.
I'll look into whether there's any.
But we're not interested in it if it ain't in the decision.
No, I understand. If there's anything in the decision of relevance, we'll provide you with the references. In terms of why what the CMA described as the assured base did not switch, the CMA looked at that. As I said, in a sense, it could have stopped with the quantitative evidence. That's important because that's all undisputed. What the CMA did, though, is that it exercised its information gathering powers, gathered a host of material from pharmacies and wholesalers. The conclusion it reached on the basis of that evidence, it's page 3.
Can I just ask, is this evidence referred to in the... this was in the CAT, in the course of the CAT, wasn't it? So it's not in the decision, but it's in the CAT.
No, so this was prompted by a request from the tribunal during the trial, because, in fact, although the decision, as I showed you, referred to the financial incentive, it didn't seek to quantify it.
Yes.
That's how it arose. It isn't referred to in terms in the CAT's judgment. There's an oblique reference, which may be a reference to the evidence, which I showed, but it's not referred to in terms in the judgment. As I say, so the CAT, if one could go to paragraph 3.282 of the decision, which is, I think, on page 783, where just underneath table 3.8. Sorry, just scroll down. Sorry, right to the bottom of the page, please. Yeah. That is essentially that's the CAT's, that's the CMA's conclusion as to the explanations for the quantitative evidence. Essentially, there were some pharmacies, this is 4 lines down, that determined they could not or should not dispense skinny label hydrocortisone tablets because of their assessment of the potential regulatory risk from dispensing off label. In those instances, only full label tablets were able to meet these pharmacies' needs. And it goes on to say that it's only Actavis that could provide full label tablets, at least for 10 milligram. And that's the figure, by the way, for 10 milligram accounting for 96% of all hydrocortisone tablets dispensed. And this is where we see the language of no choice, which Mr. Palmer has of course taken issue with. This is essentially the CMA's finding, based on the evidence that it had gathered, as to why we see the quantitative evidence that we see in relation to the large pharmacies and the assuredness of their demand. And if we move on a little bit to paragraph 3.283 over the page, you'll see that CMA summarises the submissions and evidence that it has gathered from the various pharmacies, and it goes through each of the 10 large pharmacies that we see in table 3.8. So just to look at some of them, Boots, the largest pharmacy for these purposes at paragraph B, it determined which product to purchase based on whether the product was fully indicated. Although price was a factor that Boots generally considered for hydrocortisone tablets, price was not a factor. Sorry, for hydrocortisone tablets, price was not a factor because licensing indications determined which hydrocortisone tablets Boots needed to use. Reference to patient safety. Boots needed a product that was licensed for adrenal insufficiency in adults, which was the fully indicated product. And then there's some further extracts from the evidence from Boots. If you look in the footnotes to the paragraph in relation to Boots, you'll see that many of the references are to a note of a call between Boots and the CMA from the 14th of April 2021. I don't propose to go to that note, but you do have it in the reference supplementary bundle, tab 60, beginning at page 1941. and it makes completely clear that Boots was indeed committed to buying the full label product. And given the date of that document, you'll recall yesterday Mr. Palmer made a point about the CMA wrongly freezing the frame at the outset of the of competitive entry and focusing only on the assessment of regulatory risk at that stage. Well, what we see from the document, for example, from April 2021, that well past the end of the Intas period, Boots still had that position. And similarly with Lloyd's, if one looks at subparagraph C of the same paragraph, sorry, it's on the previous page. Again, it's a similar effect, and this is the second largest pharmacy. Purchasing decision was determined by whether the product was fully indicated. It considered the use of a skinny label product outside of its therapeutic indications and license when a licensed product is available, contrary to the principles of the UK medicines licensing system. Then if one looks at footnote 404, you'll see that's a reference to a section 26 response from Lloyd's dated the 17th of January 2018, again during the Intas period. So again, the CMA is not freezing the frame and only looking at the pharmacy's views at the outset of the period of competitive entry. These are views given during the Intas period in Lloyd's case. Again, you have that note, should you wish to see it.
What does it all add up to? You can show that there was stickiness, you can show that it was stickiness which must be quite effective because it involved very substantial price loss. We have some evidence of reasons. They may not be entirely satisfactory to explain why there was this price stickiness, but nonetheless the stickiness appears to be evidenced.
Yes. Well, in my submission, for the purposes of dominance, as I said earlier, the precise reasons don't really matter. It doesn't matter, for example, whether the pharmacies, insofar as they regarded there as being a regulatory risk arising from off-label dispensation in relation to this product,
security of supply, or a multiplicity of different
reasons. What matters is what they considered the position to be, as revealed in their evidence to the CMA and the subject of a factual finding by the CMA on the basis of that evidence. Whether, in fact, as a matter of legal reality, they had a choice is neither here nor there. What is relevant for dominance is what they considered the position to be, because that's what determined their lack of elasticity to a very significant price differential.
It's whether it was sufficient to give Intas an appreciable power over price during the period.
Exactly so. As Mr. Palmer confirmed in a response, I think, to my Lord Justice Flaux yesterday, there is no evidence that the pharmacies ever changed their position on this, at least during the Intas period. Mr. Palmer said in that regard that Aptavis could not know that, say, Boots wouldn't switch. But we saw the table. In 2017, even though there had been, so 2017, during the Intas period, even though there had been substantial skinny entry by that time, Boots was still buying nearly 100% of its tablets from Actavis.
Yeah.
How much more assurance did Actavis need about the large pharmacy chain's lack of propensity to switch away than that? In my submission, what really matters...
A valid point about the note in April 2021, Boots is still saying the same thing.
Indeed.
4 years later.
Indeed.
It's pure speculation, not borne out by any evidence.
It is. So those are the key factual findings in the decision on the assured customer base. I'm just going to show you briefly how they were taken account of in relation to dominance. Just to tell you where I'm going with this, I'm then going to show you a few pieces of evidence from the trial that you haven't seen yet, but were also before the CAT on this very issue, some expert evidence and some factual evidence, and then I'm going to go directly to...
Then you get to the bit you like least, the CAT judgment.
Well, no comment, but I will definitely get to the CAT judgment. The assured base and dominance in the decision, if we could pick it up at page 1052, under the heading Market Context. So this comes after all of the analysis, all of the diagrams I've shown you on market shares, price premium, and so on and so forth. This is really the standard framework for analysing dominance. Market shares first, other evidence, and then one looks at contextual factors, barriers to entry, barriers to expansion, and so on. Paragraph 4.288, the CMA's making the point that in the ordinary case, when a drug is in the third stage of the drug life cycle, independent entry can usually be expected to lead to significant erosion of an incumbent's market power. However, as explained above, following independent entry in these markets, Actavis retained its preponderant market position, holding substantial market shares and charging prices significantly above its costs and its competitors' prices. And then, as I say, the CMA gives its reason, its explanation for that, which is the orphan designation granted in respect of Plenidrin, giving rise to the barrier to expansion and providing Actavis with an assured customer base. So that's really my point from earlier about the legs of the stool. The CMA is clearly distinguishing between Actavis's ability to retain substantial market shares and to charge significantly higher prices than its competitors, and the key factor, as it puts it, contributing to this ability, in other words, the barrier to expansion presented by the assured customer base. If we move on to paragraph 4.295, in fact, that's just the same point. And then, sorry, if we go on a few pages to paragraph 4.311, which Mr. Palmer showed you, you'll recall this is the paragraph talking about switching and non-switching both being reasonable positions to take. That was the CMA's view. Both the large pharmacies and the independent pharmacies took a reasonable position. My Lord Justice Green, you observed yesterday that if it was reasonable to switch, then potentially one could use the leverage of switching back, as you put it. And Mr. Palmer agreed with that suggestion. That was at page 164 of yesterday's transcript. To be clear, the point that the CMA is making here in the decision is that given that the larger pharmacies took the position they did in relation to off-label dispensing, they had no choice but to buy from Actavis because it was the only supplier with a full label product. Those pharmacies had no leverage precisely because they were not willing to switch away. And can I show you just one more relevant passage from the decision on that point about leverage? It comes in the next section of the dominance analysis in relation to countervailing buyer power or the absence thereof. If we could go on, please, to page 1066, paragraph 4.345, considering the potential of countervailing buyer power being exercised by Actavis' customers, in other words, the pharmacies and wholesalers. And can I just show you the findings at subparagraphs A to C? Paragraph A, there's a reference to evidence from Alliance, one of the wholesalers, about having no option but to accept price increases by Actavis. That admittedly is before the Intas period, given that it's talking about price increases. But then at B, the evidence shows that Actavis did not face realistic threats from customers to switch purchases to an alternative supplier if it did not reduce its price. Intas stated that it was not able to provide the CMA with any written documentation showing AAH Lloyd's or Alliance Boots overtly threatening to switch their hydrocortisone tablet demand away, or any internal documents showing decision-making or strategy with respect to such threats. And consistent with that evidence that Intas provided to the CMA, Boots and AAH, on behalf of Lloyd's, confirmed that they did not threaten to switch their business away from Actavis's hydrocortisone tablets. And then at C, there's a reference to some evidence that Actavis did not negotiate on price with its customers. For example, DE Pharma told the CMA that Actavis Accord refused to compete on price with thinly labelled tablet entrants. And I show you these both because it pertains to the point about the absence of leverage, and obviously because it provides further clear factual evidence in the decision of a firm that has an appreciable degree of independence, not only from its competitors but from its customers, which is another aspect of the classic definition of dominance. Before turning, I promised, to the judgment, may I just show you some other important evidence that was before the CAT on the issue of the assured customer base, which Mr. Palmer did not mention in submissions yesterday. The first is the expert economic evidence that was before the tribunal on this exact issue. Now, in its appeal to the CAT, Intas challenged the assured customer base findings in the decisions via a report from its highly experienced expert economist, Mr. Simon Bishop, partner and co-founder of the well-known firm RBB, I won't turn up the report, but you do have that at reference supplementary tab 3, page 49, and the key section begins at page 69. And the short point is that Dr. Bishop's evidence was that there was no credible evidence that a significant proportion of customers were captive to Accord UK. And as I say, this evidence from Dr. Bishop, this written evidence, was the primary basis on which Intas challenged the assured customer base before the CAT. It chose to approach the issue via the use of expert evidence. But importantly, Dr. Bishop was out on a limb on this point as between the experts. And can I show you, please, the joint expert statements for the proceedings in the CAT? That's at reference supplementary tab 5, page 173. Reference supplementary. Yeah. So we look at proposition 26 at the bottom of the page. So the that's great. Proposition is that for some customers, generally large pharmacy chains, skinny label 10 milligram hydrocortisone tablets does not constitute a meaningful substitute despite its significantly lower price, and so those pharmacies had no choice but to purchase Auden Actavis's tablets. And then we see the next column along is agree, and that's Professor Belletti, who was the CMA's instructed expert in the appeals. But then you see also that in the next, you can't see the names at the top, but the next column along is Dr. Bennett, who was the expert who was giving evidence for the Sinvan appellants. He agrees with the proposition about the assured customer base. And then similarly, Mr. Holt, who was the expert for, I think, Miss Ford's clients, the Appellants, and he also agrees. Sorry.
For advance, not for...
Oh, I'm sorry. I'm so sorry. For the Appellants. So there was a consensus there among the three instructed experts for those three parties, in agreement with the proposition about the the assured customer base based on their assessment of the evidence in the case. Dr. Bishop, you can see if you move forward to page 191 of the joint expert statement, proposition 69. So this is the proposition appears again in similar form, but this time in relation to the post-entry period. Proposition: there were certain customers that considered themselves unable to switch. Again, obviously, Professor Belletti for the CMA agrees, and then the next column over is Mr. Bishop's position for Intas disagree. But as you can see, he was an outlier on this point, as between the independent experts instructed below. What happened next is that when the CMA cross-examined Mr. Bishop on the relevant aspects of his report on day 7 of the trial, by reference to the documentary evidence on which the CMA had relied in its decision, he essentially accepted candidly that he had got it wrong. I don't propose to take you through the cross-examination in detail. It's summarised in the CMA's written closings from the trial at paragraphs 264 and following, and you have that at core supplementary tab 3, page 444. You also have the transcript, if you wish to look at it, of the relevant cross-examination, beginning at reference supplementary tab 22, page 1574. Now, there's no dispute about the effect of Mr. Bishop's evidence orally. What happened in closings is that Intas backtracked from reliance on Mr. Bishop and said that under pressure of cross-examination he had essentially got it wrong. That was a hopeless submission to make. Dr. Bishop was a highly experienced expert witness. There's no reason at all to think that his oral evidence was extracted under pressure of cross-examination. And as I said, it was Intas that chose to rely on his expert assessment of the evidence in order to challenge the assured customer base finding. Now, it was a curious feature of Mr. Bishop's evidence in his original report for the trial that it was actually at odds with the evidence of Intas's main factual witness, Dr. Burt, who you've heard about. And this is the second piece of evidence from the trial that I'd like to show you. Could we turn up, please, Supplementary Core Bundle, tab 16, page 194. Just scroll down the page a little. First witness statement of Dr. James Burt. Just over the page at paragraphs 2 to 3, you can see Dr. Burt sets out his role at the company and his experience, his extensive experience in the pharmaceutical industry. Could we go on, please, to page 209? In fact, page 209, the heading at the bottom of the page, the economic value of full label products. And then at 55, CMA makes statements in the decision about the Accord UK hydrocortisone product having no economic value over cost plus. I do not agree with these statements and they do not accurately reflect the product or market. Over the page at 56, all our customers had a choice whether to buy from us or to buy from one of the skinny label manufacturers. In my experience, and this is based on the many years I've worked in the industry, price is just one factor in the decision to do business with us. But then, could I just invite you please to read paragraph 57, which is my submission is the key paragraph from this Dr. Burt's evidence that's relevant to the issue we're discussing. So this is Intas's own factual witness.
Can we just scroll to the bottom of that paragraph?
Oh, I'm so sorry, yes.
Okay, yes, more.
Yeah.
Yeah.
So, don't think you were showing this yesterday. This is Intas's own factual witnesses. What he has articulated there in substance is none other than the assured customer base point from the decision. He is specifically saying in his evidence to the tribunal, some customers, particularly the larger pharmacies, considered it important to adhere strictly to the regulatory regime and not to stray outside a product's marketing authorisation. And he is referring in particular to concerns that some pharmacists may have about a change of brand to an off-label, skinny label product, something that might risk destabilising a stable patient. Yep. Safety consideration. You see the points. Okay. Now, Mr. Holmes is going to come back to the question of whether the full label indication constituted legitimate economic value, justifying a vast excess of price above cost plus, and also some of the other factors that Mr. Palmer did take you to, the other points referred to in Dr. Burt's evidence. But in my submission, in relation to the assured customer base, that really shows that in addition to the expert evidence before the tribunal below, the factual evidence from Intas itself really did support the findings that were made by the CMA in the decision. And that's important context when one comes to look at the judgment. And we are now finally going to go to the judgment. Now, just to remind you, Intas's submission on this appeal is a stark one. It says that the CAP did not endorse the CMA's findings on the assured customer base. I think Mr. Palmer said yesterday that it was heroic for the CMA to suggest otherwise. And in fact, Intas goes further and suggests that the CAP positively rejected the assured customer base point when it was analysing market definition. My submission, that's simply wrong. The CAP does indeed endorse the CMA's findings on this point. it does so through both the general endorsement of the factual findings in the defence concerning the regulatory regime that I showed you at the start of my submissions, and I'm not going to go back to, but it also does it through a specific consideration of the assured customer base points, albeit it doesn't generally adopt that term. It principally does that in the specific context of market definition, but it does also come back to the point in relation to dominance. It absolutely does not reject the distinction drawn by the CMA between the assured base and the smaller pharmacies who are prepared to switch to the cheaper product.
Okay. Give
So
us the paragraph numbers. We're on
Yes.
hooks.
Well, I'll swiftly take you off them. So if we look at page 320, yes, exactly, core bundle, page 320. Heading the regulatory regime. And do you remember I showed you the paragraph earlier that said that the CAT endorsed the factual findings in relation to the regulatory regime, and this is the relevant section of the CAT's judgment. We move on to page 332. There's a heading just towards the bottom of that page, the pharmacy. Paragraph 79, the reference to pharmacies being obliged to fulfil prescription, but a reference then to them having a discretion if a prescription is over. So that's the point about pharmacists being permitted, having a discretion to dispense off-label. And over the page at paragraph 80, the CAT gives what it calls an example that is not hypothetical, but very much drawn from the facts of the case. He invites the reader to suppose that there are two medicinal products, A and B, with the same active ingredient, same therapeutic indication, save that one of them specifies that A is indicated in adults, whereas the other one's marketing and authorization specifies that B is indicated in children. And then let's suppose that make some suppositions about the relative prices of the products. Paragraph 81, the CAT says that assuming a legally unconstrained choice between A and B, then rationally, and assuming no issues about the supply of each medicinal product, the pharmacy will elect to supply A. The pharmacist will be entitled in such a case to presume that the doctor has elected to go off-label, and obviously the point being made there is that, again, assuming a legally unconstrained choice, the pharmacist will have the incentive to choose the cheaper product, which is the point you saw in the decision as well. But then at 82, the CAT makes the point, the finding, that is very much what a rational pharmacy with perfect legal knowledge would do. But the law in this area, as we shall see, is by no means straightforward. And we considered that there would be a strong prudential motivation amongst pharmacists to dispense the age-appropriate product, even if it was not legally obliged to do so. This was the evidence of Dr. Newton, to which we should come. We haven't heard, I think, about Dr. Newton yet. She was an expert called on behalf of the Advanced Appellants. She was an expert witness giving the perspective of a pharmacist. And if we could go on to page 335, can you see under the heading, I'm so sorry, I'll show you paragraph 88. This is just the tribunal's conclusions on the law, which it distinguishes from the market's understanding of the law. And if you just quickly read through that, essentially this is, again, the point about the distinction between off-label facilitation, or in other words, marketing, and off-label prescription and dispensing, and the legal difference between the two. It's consistent with the CMA's findings on this issue. But then, under the heading Market Perception, immediately below, CAT says, we will consider the extent to which market perception of the regulation of off-label facilitation matters later on in this judgment. For the present, we simply set out our findings in relation to the evidence we received. And there is then a description of Dr. Newton's evidence, and then there's 7 sub-paragraphs as one looks over the page. CAT says we can set out the position shortly. I'm just going to show you...
So really the evidence goes to paragraph 90, isn't it? I mean, there's a description of what happens when there's an open prescription, and it makes the point that when there's an open prescription, there may well be some element of uncertainty or regulatory concern.
Yes, well, that I can.
I've just been reading ahead.
No, exactly. So can I just show you before we get there? That is exactly the point, my lord. That if we can show you paragraph 7, subparagraph 7 of this, these findings in relation to the evidence from Dr. Newton, the CAT's making the finding in light of that evidence. What matters less is the strict legal position than the perception by the market. That's what determines market practice. That's, again, fully consistent with the CMA's analysis. Viewed in this way, we accept the general trend and direction of the evidence of Dr. Newton, although not the ultimate extremity of Dr. Newton's position. So the implication of a doctor issuing an open prescription where there is a choice between two products, both a proper response to the medicament prescribed, but one resulting in on-label use and the other in the off-label use, is that the on-label dispensing outcome will generally be perceived as preferable. And then, my lord, exactly as you say, if we go to paragraph 90,
But it's really it's 7 subparagraph 2, the last sentence.
Yeah.
We're prepared to accept that a risk-averse pharmacy might very well hold views like those of Dr. Newton, even if the CAT didn't accept their views were extreme as he believed. And then there's the point in subparagraph 8 about the systems were not always that easy to identify the non-prescribed version or the open versions.
Indeed. I'm grateful. And then at paragraph 90, as you say, my lord, this is the CAT's finding on this evidence. There was a sense within the body of pharmacies in the United Kingdom generally that within the case of open prescriptions, the preferred course was to dispense the pharmaceutical product, etc., etc. So then if we could move on, I showed you at 89 that the CAT said it was going to come to consider the implications of those findings for its substantive analysis. We go forward to page 353. Can you see the heading? Sorry, if you scroll down, yes. At C, implications and relevance of Plenidrin. I'm just checking. I think we're still in section D of the judgment, so the factual findings on the regulatory regime. Paragraph 140. So this is it. Yes, this is it. So the tribunal finds that Plenidrin is significant for a second reason, in addition to its possible status as a substitute. Sorry, I was trying to find the first reason, but the first reason is the arguments about comparators, which, as I said, Professor Bailey is going to deal with. But the second reason is what matters for my purposes, and this is the point about Plenidrin's status as an orphan medicine. And this is all of a piece with the findings I showed you in the decision about Plenidrin's status as an orphan medicine and its impact on marketing and authorisations, and the full label and skinny label distinction is then introduced. Then at paragraph 141, the tribunal says, self-evidently, this must be a relevant factor for our consideration, and a great deal of evidence and submission was devoted to the point, including, of course, the submissions from Mr. Palmer. Indeed, this is why the evidence of Dr. Newton, which we have described, is so important. Now, and again, the CAT delays the punchline and says our analysis again comes later in this judgment. But it's clearly indicating here that it considers the orphan designation to be important for its subsequent analysis. And as I say, its analysis of the effect of Plenidrin and the orphan designation is fully consistent with the CMA's findings in the decision, and that cross-reference to Dr. Newton's evidence is a reference to what I just showed you earlier in the judgment. And drawing the threads together, and we'll see this a little bit more explicitly in a moment, clear implication is that it's the orphan designation combined with the evidence on regulatory perception that impacted the willingness of the so-called body of pharmacies to buy the skinny label product. In other words, exactly what the CMA found in the decision as regards the assured base. Now, as I say, the CAT delays the punchline, but some of the key specific findings come in the market definition section of the judgment. that contains an even clearer endorsement in my submission of the CMA's findings. Now, as you know, it's not directly an issue on this appeal, but the CAT took issue with various aspects of the CMA's market definition analysis, including in particular its exclusion of certain products, Plenidrin being one of them, from the market. But the CAT, as you've seen, decided it could remake the decision on market definition for itself, and I showed you earlier the paragraph that relied in that context on what, and the CAT said, almost without exception, we've accepted the many detailed factual findings in the decision. That was paragraph 341. So that was one of the reasons why the CAT said we consider that we can take this decision for ourselves. We move on to paragraph 240. Page 405. Sorry, yes, that was a paragraph I showed you at the start. Paragraph 243 over the page. This is the CAT's key reasoning, its explanation of its alternative market definition analysis. And what you'll have seen is that the CAT takes an approach which effectively abstracts away from the facts of the market and hypothesises what it describes as a theoretical consumer who has some of the characteristics of a patient, some of the characteristics of a doctor, some of the characteristics of a pharmacist, and so on. The CAT rejects a traditional SNP analysis. As it says, the CMA had done the same. As I say, its general approach was to come up with this hypothetical consumer comprising the salient characteristics of doctor, pharmacy, and patient. That's at 243, subparagraph 6. And then if you look at subparagraph 4 of subparagraph 6, Mr. Palmer referred you to this yesterday, the hypothetical patient, the subject matter of the alternative market definition analysis, is said to have an understanding of the difference, in this case, between skinny and full label offerings and the regulatory regime that created that distinction. Again, what can that reference be other than a reference to the assured customer base to which the CMA refers in its decision, and it's covered earlier in the decision, in the judgment, as I showed you. The CAT then asks what price a SNP should be applied to when considering how this hypothetical consumer would react to a SNP. So this is a slight curiosity. Although the CAT says it's rejecting a traditional SNP analysis, by which it means, I think, an analysis that uses the existing prices in the market and indeed looks at the reaction of real firms in the market. The CAT is considering how it should apply that analysis in relation to its hypothetical patient. And if one looks at subparagraph 8, the CAT indeed makes this point. Subparagraph 8, subparagraph Roman 1, normally tests for market definition take the prices in the market precisely because they are market prices. But then subparagraph 2 over the page, where the market prices are, rather where the actual prices in the market are not market prices, which I think must mean not competitive prices, the justification for sticking with the actual prices ceases. In this case, we do not consider that the prices for any of the products in issue can or should be relied upon. This is for a variety of reasons. What the CAT is describing here, I think, is the well-known cellophane fallacy, and indeed it says that in terms at footnote 315 of the judgment. That's the well-known fallacy of defining markets by reference to patterns of substitution that one observes at prices that are already inflated, in particular issue in abuse of dominance cases, because in those circumstances substitution may overstate the extent to which products are truly substitutes for one another. So that's what the CAT is talking about here. And then subparagraph 5, just a bit further down the same page, the prices of potential substitutes are not the outcome of consumer choice. That is talking about potential substitutes including the skinny label products, Plenidrin, and so forth. They are not a market price, the CAT says, for reasons that we have already set out in depth, and then it recaps. And then if we could go over the page to, slightly lost track of the subparagraphs, but subparagraph B of another subparagraph. The orphan drug status of Plenidrin is distorted in two respects. Then first, the point is made about the impact of the orphan designation on Plenidren's own price, which is relevant to the comparators issue, which Professor Bailey is going to address you on tomorrow. But then at C, this really is the key paragraph, if you wouldn't mind reading it to yourself, and I think Mr. Palmer did take you to this yesterday. My lords, that is an unequivocal finding that pharmacies, generally the larger pharmacies, regarded skinny label as a different and non-substitutional product. That's described as the distorted outcome of a market that is not, in any real sense of the word, a competitive market. And in particular, as we've seen for the preceding paragraph, that is said to be the outcome of the orphan drug designation of Plenidren. So that is exactly the finding that the CMA reached in the decision. It's the impact of the Plenidren orphan designation acting as a barrier to expansion. It is exactly the same finding. It's a specific endorsement of it. It's the assured customer base by another name. Mr. Palmer placed emphasis on the fact that this finding was in the context of market definition, and in particular in the context of the CAT's finding that Plenidren's price was not a good benchmark for the purposes of a SNP analysis. But in my submission, that's nothing to the point. The key point is the CAT is here making a factual finding based on the evidence about the lack of substitutability between full and skinny label from the perspective specifically of large pharmacies, the assured customer base. It is another way of putting the CMA's point that the large pharmacies had no choice but to buy from Actavis. Mr. Palmer made the point also that these findings are not tied to any particular time period. To my submission, that's not a good point. By definition, these findings relate to the post-entry period because they concern the position. They can only concern the position after skinny label suppliers have entered. That's the period from October 2015 onwards, really from March 2016 onwards, when one first started to see substantial entry. But as I said, there is no evidence of any change in position on the part of the big pharmacies as regards their attitude to skinny label products, and Mr. Palmer confirmed that on several occasions yesterday. So my submission, this finding can properly be construed as fully applicable to the part of the post-entry period comprised by the Intas period. Of course, this is a factual finding, and in light of the bedrock of evidence in the CMA decision on this point, which, as I've said, the CAT endorsed, it is hopeless to suggest that it was not within the CAT's margin of appreciation. Mr. Palmer said then that this point in the context of market definition, was not dealt with in the dominant section at all. I'll show you in a moment that that's also wrong. The CAT does refer back to these findings in the very context of dominance. Can I first, though, address the argument that the CAT rejected the market definition argument that had been put forward by some of the other appellants, Sinven and Advance, that the market had divided into a cautious and a less cautious group. Mr. Palmer took that as a rejection of the assured customer base finding, and I'm afraid that is wrong again. It's simply not a tenable reading of the judgment. It is true, as you've seen, that the CAT found that full and skinny label tablets were in the same product market, but as I've just shown you, it found that the large pharmacies within that market did not regard the skinny label product as a substitute for the full label product. Now, on one view, that could have resulted in a finding that there was a discrete market for full label supply. On that market, Actavis would have been a monopolist during the Intas period, and the case on dominance would have been even easier. If I could show you page 403 of the decision, of the judgment, under the heading the Sinven and Advance Appellants. So we're 403.
Sinven and Advance.
So we're still in market
232 and following.
Indeed. So we're still in market definition. This is actually before the CAT comes to remake the decision. You can see it, paragraph 232, that the Sinven and Advance Appellants were proposing that there were separate markets for full label and skinny label tablets, and therefore appealing against the finding in the decision that there was one market encompassing both. As I say, in relation to dominance, actually this would have helped the CMA if there were separate markets, because there would clearly have been dominance on the narrower market for the supply to the large pharmacies. You see at 233, according to their analysis, that's the analysis of those appellants, the entry of skinny label tablets led to a bifurcation in the market, and some of the evidence is set out about the assured customer base. And in fact, this is the one place in the judgment where the CAT utilises the terminology of the assured customer base, albeit that it's in fact a term that's taken from the decision. And this is
It's 235 and 236 which contain the key conclusions.
Indeed. So if we go to 235 and 236, well, in fact, sorry, I'll show you 234 just quickly. And this is a reference again that, in short, after the entry of skinny label products, there was a bifurcated market reaction that needed to be understood. The problem was that the market did not behave in the manner that Dr. Newton considered that it should have behaved. And then there's a reference in very broad brush terms. Again, there's a reference to the impact of the entry of skinny label on the larger pharmacies, who took an approach in line with that articulated by Dr. Newton. And then it's subparagraph 2. On the other hand, the smaller pharmacies did not take the approach articulated by Dr. Newton. Instead, they focused on the higher margins. 235, we accept that the interaction between full and skinny label represents an extremely odd case of substitutability. The presence of some switching is not necessarily sufficient to indicate products are in the same market. What is needed is some understanding of why switching is occurring so that the relationship between cause and effect can be measured. In this case, despite a really quite material price differential, a significant part of the market did not switch to skinny label. Here's the finding. That was due to non-price considerations of the sort we have described. So the CAT is there accepting, as it says here, that a significant part of the market did not switch due to non-price considerations. And the reference to of the sort we have described must be a reference to their perception of the regulatory risk, as had been discussed earlier in the CAT's analysis of Dr. Newton's evidence, and again, fully consistent with the decision. And then at 236, skinny label tablets certainly did not fully constrain full label prices because significant proportions of the market were indifferent or prepared to forsake the additional margin afforded by skinny label products. That's what I anticipate may be the oblique reference to the analysis I showed you earlier that the CMA produced the trial. We don't know, but be that as it may, that is the CAT's finding.
So you say, putting all these findings together, wherever they are in the judgment, what it demonstrates is that in relation to the issue of dominance.
Yes, and I'll show you.
Plenty of findings to the effect that there was an assured customer base, even if they only used the phrase once.
Indeed. I'll show you in a moment how that played into the analysis of dominance specifically. But as I say, exactly as you say, my lord, the analysis is a little scattered throughout the CAT's judgment.
If what they're doing is describing the regulatory regime or the market in various places in the judgment, the findings of fact aren't in sort of silos. So that if you make a finding of fact in that silo, it doesn't apply to any of the other silos. Yeah. Unless, of course, they say, well, even if that finding relates to that silo, it can't cross over to other parts of our judgment. But otherwise, by process of normal analysis, you said, well, the findings of fact are the findings of fact.
Yes. And it's for that reason, my lord, that one has to be very careful about submissions about the reasoning on dominance being extremely brief, concise. One has to read it with the references back to the judgment as a whole. But as I say, I am going to show you in a moment that there was a reference back to this, these clear findings in the context of the dominance assessment. But to be very clear, we say that on the basis of the passages I've shown you, the factual findings in relation to the regulatory regime, Intas is simply wrong to say that there is no endorsement of the CMA's findings on the assured customer base. And it is completely wrong to say that was rejected. In relation to these arguments from Sinford and Advance, it wasn't rejected at all. CAT said, we agree, it's an extremely odd case of substitutability. The CAT didn't think that meant that there was a separate market, but that's a point about market definition, not about the facts. Can I then show you the CAT's analysis of dominance specifically, with apologies for having taken this long to get there. As I say, there is no doubt that the analysis is quite brief, but as I say in my submission, it needs to be read together with the earlier analysis that we have seen of the regulatory regime that I've just taken you through in some detail. The key difference between the CMA's approach to dominance and that of the CAT is that, I think I made this point earlier, while the CMA distinguished between two broad periods, the pre-entry period and the post-entry period, the period after the skinny label suppliers had started to come into the market, the CAT preferred an approach that focused on the different phases of ownership of the Actavis entity, the entity that held the full label marketing authorization for hydrocortisone tablets. But as I'll show you in a moment, the CAT's own view was that that distinction, that difference of approach, made no material difference to the outcome on dominance. So could we pick it up, please, at paragraph 277 of the judgment? Page 426, an assessment of dominance by phase. Sorry, a little higher up. So, CAT's explaining its approach, but at the start it's interesting to note that it sets out, it says, we turn to a more specific consideration of dominance, but we do so against the background of what would appear to be uncontrolled prices and an ineffectual scheme of regulatory control in a market where demand is inelastic because it's based on medical need. For the reasons we have given with regards to such factors as background factors to be accorded a secondary weight, that's the reference earlier in the judgment to the dangers of relying on price as evidence of dominance in an excessive pricing case. That's the reference there. Then but the CAT does say it's important to appreciate that those price-related factors point towards and not away from dominance, and I've obviously shown you some of the key pricing evidence that appeared in the decision, which was obviously before the CAT. Then at paragraph 278, CAT explains its so-called phase-by-phase approach, and we propose to consider the question of whether a state of dominance existed by reference primarily to market share on a phase-by-phase basis. And then over the page at 428, you see, sorry, the next page, you see the tables my Lord Justice Zacaroli referred to earlier, and as I say, the underlying data here is exactly the same data that the CMA gathered and presented in the slightly different, the colourful diagrams on market share. Yeah. It is precisely the same data. And unsurprisingly, given that the CAT had said it was going to take an approach that focused on the various different phases of ownership, if one looks at paragraph 289, which is quite a bit further on, in fact, at page 439, you see specific consideration of the Intas phase, in other words, what we've all been calling the Intas period, and then the sales and market share figures are set out. And as I say, just to reiterate, they are exactly the same market share figures as those set out in the decision. So having done that, having specifically set out the data in relation to the Intas period, we then come to the CAT's conclusions on dominance. And just to make an obvious point, having preceded that analysis with a specific recognition of the market share position during the Intas period, it is obviously the case that CAT had the Intas period in mind when then coming to its analysis of dominance. And if we look at paragraph 291, sorry, page 441, yes, under conclusions. We conclude that the undertakings which we have found them to be during all 5 phases had a dominant position in the markets as we have defined them. All 5 phases, obviously, including the Intas period, which has just been mentioned above. There are a number of indicators that justify this conclusion, and then the CAT refers to the 3 pricing-related factors. Now, Mr. Palmer made the point yesterday that those factors do not, and it's true, they don't pertain to the Intas period specifically. These are about the other side of the Matterhorn when prices were being increased. But as we see immediately from paragraph 292, the CAT is cautious about placing too much weight on them. Again, that's because of its view about the dangers of reliance on price-related factors, certainly evidence of excessive pricing, when that is exactly the issue you're seeking to consider in the case, when you're looking at whether there's been an abuse in the form of excessive pricing. So it's certainly not relying on those factors as evidence of dominance in relation to the Intas period. And then the end of paragraph 292, last sentence, we prefer to have primary regard to market share and to consider market share by reference to the various temporal phases that we have defined. paragraph 293, it's clear from the analysis set out above that the relevant market shares by volume and by revenue, certainly not rejecting the CMA's reliance on the value-based or revenue-based metric, the relevant market shares clearly denoted dominance, and we regard this conclusion as inevitable from the data we have set out. And then, this is important, it's true that market share fell over time. In phase 1 it was 100%, but it was rarely, if ever, and there's a footnote in relation to the words if ever that make the point that when one looks at average market shares in these particular granular time periods, that can be somewhat unreliable. But as we've seen, rarely if ever less than 50%, whether by volume or by revenue. And I showed you earlier that the precise market shares at the end of the Intas period were 86% when measured by value and 53% when measured by volume. So this is a clear recognition, the reference to clearly denoted dominance.
Well, also that last sentence is important, isn't it? Furthermore, the remaining share
yes.
of the market was highly fragmented amongst
Indeed,
a number
indeed,
of other competitors.
indeed.
Which was the same point as we were discussing earlier in relation to that graph at figure 319.
Yes, exactly. The point I was going to emphasise before that was the penultimate sentence of paragraph 293 is clearly a reference to the fact that market shares came down. There's a reference to 100% in phase 1, 50% later on. It clearly had in mind, therefore, the decline in shares that Intas has placed such reliance on. It is specifically addressing Intas's argument about the facts during the Intas period, and Intas was the key proponent of this argument about the post-entry period at the trial. And then, my lord, as you say, the final sentence is very important too, because it isn't a reliance merely on absolute market shares. It's a comparative analysis, which looks also at the shares of the remaining market, and a factual finding that those were highly fragmented amongst a number of other competitors, and that's fully consistent with the diagrams I showed you. This approach of placing particular weight on both absolute and relative market shares of this scale is fully consistent with the case law that I showed you earlier. The significance it is afforded as a matter of law to very high market shares. But the CAT did not stop there, and then paragraph 294, this is my point about the fact that the CAT actually did rely on the assured customer base point, the specific endorsement of the factual findings that I showed you earlier. Because what the CAT says here is that it's also significant that many of these competitors, namely those selling skinny label products, will have laboured at a competitive disadvantage when compared to the holder of the MSD marketing authorisation. We have described the nature of that disadvantage already. That can only be a reference back to the findings I showed you earlier about the strange case of substitutability, as I think the CAT puts it. That's why it's important to read this paragraph by reference to the earlier passages. There's a twofold nature of that disadvantages. First, such competitors would have sold at lower volumes than if they had a full label product to sell. That's really the point about market shares, relative market shares. Secondly, to the extent that there was demand, that demand responded to a significant discount in the price of skinny label products relative to full label products. That's really the price premium point, and that's the point I showed you from the decision. So really, on any sensible analysis, the CAT is here firmly endorsing the findings in the decision as to these matters. Paragraph 295, even where there was competition, it was of limited effect, and that is reflected in the market shares that we have recorded. And that really is another way of saying, although there's not a complete absence of competition, there's an appreciable absence of competition, and that's the definition of dominance. A few points about these paragraphs. First, in terms of the temporal point, this analysis is about the post-entry period specifically. It can only be about that period because it's about the... Indeed. I
think that's clear.
That is clear. There were no skinny label suppliers who could have been at a competitive
They
disadvantage.
only relate to the period after the skinny label suppliers started coming on the market.
And the Intas period is a
subsumed
significant part of that period,
yeah.
even if not identified specifically. We know from the earlier passage that the CAT is...
From 2015 to
Yes.
2018.
And just to repeat the point from earlier, we know also there was no material change in the Intas period as regards the large pharmacy's propensity to purchase full label rather than skinny. As I say, second point, the CAT is obviously here harking back to its earlier findings. That's the sentence beginning, we have described the nature of the disadvantage already, and it's further evidence that there was a specific endorsement of the assured customer base point. Third, saying that this had an impact in terms of the price that the skinny label suppliers were able to command. As I said, that's clearly a reference to the price premium evidence. And so in my submission, this ends up being in substance precisely really the CMA's approach to dominance. Reliance on continued high market shares, even though they have declined to some extent, high absolute and relative market shares, nevertheless the ability to maintain a significant price premium, and the explanation for that price premium is the competitive advantage arising from the orphan designation. As I say, the Intas period is not mentioned by name in this paragraph, but I have shown you the undisputed market share and pricing evidence in relation to that period. In my submission, it is unreal to suggest that the CAT did not have this in mind, given that the whole point of its phased approach was that you needed to think about the different periods of ownership separately. The right reading of this passage is that the CAT thought that this competitive disadvantage persisted throughout the entire post-entry period, as indeed the undisputed factual evidence, the quantitative evidence in the decision shows. And then, just for completeness, I'll show you also, sorry, in fact on the same page, the conclusion. My Lord Justice Zacaroli referred to this this morning. We are therefore upholding the finding of dominance in the Hydrocortisone decision. We appreciate that our approach has been different.
I think we've read this. The 2 points which they refer to go to points which are not related to the nature of the customer list.
Exactly. Nothing to do with the facts.
One's about phasing, the other's about the de minimis extension of the product market, which they say is de minimis.
Yeah. Just for good measure, I'll show you a few final paragraphs from the judgment. Again, I don't think mentioned by Mr. Palmer yesterday. If we could go on to paragraph 351. This is in the section dealing with abuse and economic value. You can see the CAT talks about having been somewhat critical of the regulatory environment that has facilitated these overcharges, and even more critical of arguments that seek to justify them by reference to the regulatory environment. We want to be clear that the fact that a misbegotten regulatory environment has engendered a dominant position, which is then abused, in no way justifies the use. So I place emphasis on the reference to the so-called misbegotten regulatory environment having engendered the dominant position. Again, that must be a reference to what the CAT describes earlier as the distortive effect of the plenigem designation. That's the only logical explanation of this paragraph. As we saw, the CMA regarded that as a regulatory quirk, to use the language from the decision, that it wasn't reflective of any innovation or any other inherent feature of Actavis's product. The CAT took a rather firmer view, not just an unintended consequence, but a failure of regulation. And there's, just to give you a few other references, paragraph 274, subparagraph 3, a little earlier.
274.
Yes, page 425. It makes the point I've just made even more clearly. We find it extraordinary that the regime for orphan drugs can provide a form of competitive protection well in excess of that conferred by patent rights. The notion that for a 10-year period, functionally very similar products can be relegated to second-class products and generate real uncertainty in dispensing pharmacies as to what they should and should not be able to dispense is both a failure of regulatory clarity and wanton over-protectionism. Strong language, but clearly, again, referring to the impact of the orphan designation in terms of creating this distinction between full and skinny label. And then finally, over the page, paragraph 276. The very deficiencies in the regime that we have articulated have created opportunities in terms of suppressing competition that form part of the hinterland that must be taken into account when considering whether a state of market dominance exists. My overall conclusion on dominance, and on Intas' ground one, is that it is sufficiently clear from a proper reading of the judgment why Intas' case was rejected. I should mention briefly Mr. Palmer's 100-page annex to his written closings. He complained yesterday that the CAT did not address that in terms in its judgment. That was a document when, after the collapse that I've referred to of Intas' expert evidence in cross-examination at the trial, Intas submitted a forensic analysis of the various documents that the CMA had referred to in its decision. It's true, I can't get away from it, the judgment doesn't refer to it. Obviously on this appeal you can't get into the detail of that annex. The CMA produced a response and that's not referred to in the judgment either. My short answer to this though is that the CAT was under no obligation to cite every piece of evidence or address every one of the array of arguments from counsel that it received during the trial. I won't go to the cases given the time, but we've cited some of the key authorities at paragraph 47 of our primary skeleton, and then further at paragraph 30D of our responsive submissions. It's well-known cases like Henderson and Foxworth Investment, Volpe and Volpe, so on. What I hope is clear from the judgment, as I've shown you, is the factors that the CAT did place significant reliance on: expert evidence of Dr. Newton about the regulatory position, the quantitative evidence about the lack of switching and the price premium. And in my submission, that was an adequate and intelligible basis on which to endorse the insured customer base finding specifically and the CMA's conclusion on dominance generally. The really critical point in my submission is that the large pharmacies voted with their feet, as shown by the fact that they did not switch across a sustained period despite the big savings on offer. No amount of forensic analysis of the documents could detract from that basic and undisputed fact. Conscious it's nearly 4:30, I've got a little bit to say on imposition, but it will take me longer than 3 minutes, so maybe a good time to finish.
3 minutes is your absolute maximum. I have a meeting starting at 4:30, which I'm not going to get to.
I think I'm doing fine for time.
How are we doing generally for time?
Do you think we could start
We can
a
start
little
at
earlier in the morning?
10:15 tomorrow.
Yes.
I think that would be helpful if that's all right.
Does that make sure everyone over here has got time for replies? And you're aiming to finish when, CMA case?
CMA case. I think I have another 15, 20 minutes.
So we have been a little squeezed by the fact the other side took more than their total allocation without leaving any time for their replies. We'll obviously cut our cloth, but with a crisp reply at the end of the process, I'm sure we can be done by 3:30.
Do you mean 4 crisp replies?
I'm so sorry?
Do you mean 4 crisp replies?
4 crisp replies, indeed. So I think it will 3 o'clock to 3:30 would probably be the landing place, if that works. Yeah.
Okay. 10:15 then tomorrow.